It is no secret that alcohol and violence are related. So when an intoxicated patron assaults another patron, it is quite often wondered who should be held liable. Is the venue partially responsible, or is it solely the assailant? This is not a straightforward question and requires some examination of cases, which present various scenarios. Generally, an occupier of licensed premises, who is in a position to exercise control over the conduct of its patrons, will owe a duty of care to protect patrons from tortious or criminal conduct by other patrons on the licensed premises. This goes against the notion that there is generally no duty of care to protect a plaintiff from the criminal actions of third parties. Although, with that being said, a hotel's duty to protect patrons from injury by other patrons involves different consideration from a regular duty of care. For example, the duty to protect patents from injury by an inanimate object. The majority in Wagstaff and Haslam said that the mere fact of a degree of intoxication will not give rise to a duty to take immediate steps to remove the affected person, in order to protect other patrons. An additional element is required. That element is knowledge, either actual or constructive, of the aggressive character of the person, when intoxicated, based either on known characteristics or conduct on the occasion in question. The courts place great importance of having properly qualified experts, or an industry standard, establishing what is reasonable conduct in response to situations of the kind which the plaintiff was involved in. Negligence should be established by examining the appropriateness of the conduct at the time, and not measuring how they should have acted in hindsight. The classic example of the duty owed by licensed venues can be seen in Adil's Palace and Mubarak. The facts are as follows. The defendant ran a nightclub in Punch Bowl known as Adil's Palace. It held a New Year's Eve function attended by members of the public by payment of an admission price. In the early hours of January 1, 2003, a dispute on the dance floor erupted and came to involve a fight between the plaintiff, Mr. Mubarak, and a Mr. Abbas. Mr. Abbas left the premises and returned with a gun. It was agreed that when he returned, Mr. Abbas shot Mr. Mubarak and Mr. Bnajam. The plaintiffs brought proceedings against the defendant all the way to the High Court, claiming damages for negligence, or in the alternative, for breach of contract. The majority confirmed that intoxication is not a necessary element to invoke the duty owed by a hotel. The duty arises because of the foreseeability of injury from conduct on the premises and the capacity of the defendant to control that conduct. So although the hotel did owe a duty from the typical violent, quarrelsome or disorderly conduct of other persons, the hotel could not be reasonably held to foresee that kind of incident, nor would it have been able to control it had it known. A particular issue was causation, that being the but-for test, as having security at the front would not necessarily alter the outcome for the plaintiffs.